Democracies don't collapse when tanks roll in. They collapse when a judge has to threaten jail just to make the law matter. Think about that. A federal courtroom, a sitting FBI director, and a judge saying publicly comply by December 20th, or you will be arrested and held in custody. No hearing, no delay, no politics, just enforcement. This was not theater. This was the judiciary reaching the end of its patience. I want you to understand what pushed the system here. Because this moment isn't about Epstein files. It's not even about Trump. It's about something far more dangerous. A senior executive official deciding that court orders are optional. I've spent my life studying how power behaves under pressure. And here is the rule. History never breaks. When those entrusted to enforce the law begin defying it, the system enters a countdown. If you want analysis that goes deeper than scandal and outrage, stay with me. Share this not to inflame, but to understand. Because before we talk about consequences, we must confront why the rule of law was forced into an ultimatum. So let's be precise about what this confrontation actually is. This is not a dispute over paperwork. It is not a misunderstanding between branches of government. And it is certainly not about protecting sensitive investigations. What unfolded in that courtroom was a direct collision between judicial authority and executive defiance. A federal court issued lawful orders. Not once, not twice, but repeatedly. Over 6 months. Each time, the same response. Delay, privilege claims, procedural fog. And each time, those claims were rejected by multiple courts. At some point, refusal stops being legal argument and becomes obstruction. That is the line Judge Berman was forced to draw. Because if the FBI director can decide which court orders to obey based on political convenience, then law enforcement no longer enforces the law, it negotiates with it. And once enforcement becomes selective, accountability collapses fast. This is why the judge's question mattered so much. Not what documents were withheld, but who believed they had the right to withhold them. Before we examine how this crisis formed, we need to understand how power learned to test the limits of law itself. Crises like this don't appear overnight. They are built slowly through habits that go unchallenged. For years, powerful institutions learned a dangerous lesson. Delay works. If you stall long enough, if you bury requests in procedure, if you wrap refusal in legal language, consequences often disappear. Oversight weakens, attention fades, time becomes a shield. That pattern hardened here. Congress issued subpoenas. Courts issued orders. And each response followed the same cycle. Claim privilege, request extensions, promise future review, 6 months passed, then more. Each delay quietly tested how serious the system actually was about enforcement. Most systems fail, not because rules are unclear, but because enforcement becomes optional for the powerful. And when executive officials begin treating judicial authority as negotiable, something fundamental shifts. The balance between branches tilts. Law becomes a suggestion rather than a command. By the time Judge Berman reached that December hearing, this was no longer about documents. It was about restoring a boundary that had already been crossed too many times. Once a system tolerates defiance, escalation becomes inevitable. And that escalation is what brought the judiciary to the brink. The breaking point arrived the moment the judge stopped speaking in hypotheticals. This wasn't another warning. It wasn't another extension. It was a direct question asked in open court with consequences attached. Will you comply? Yes or no? That question stripped away every legal maneuver that had worked for months. No privilege claims. No procedural fog. Just a choice, obedience, or defiance. And when hesitation replaced compliance, the system reacted. A federal judge made something unmistakably clear. Contempt of court is not symbolic. It is enforceable, arrestable, immediate. That is when the crisis became real. Because once a judge publicly states that the head of the FBI could be jailed without a hearing, the judiciary is signaling that institutional patience has run out. I want you to pause here, because moments like this are rare. They reveal how close a system is to failure. When enforcement has to be threatened at the highest level, something has already gone very wrong. If this analysis matters to you, share it now. Not to shock, but to remind people that accountability still exists, even when it has to be dragged back into the room. What followed was no longer negotiation. It was escalation. What looks like defiance is rarely impulsive. It is usually strategic. The hidden mechanism here is simple and deeply corrosive. Delay as power. When executive officials believe they can outlast oversight by invoking privilege, demanding reviews, and stretching timelines, they aren't defending law. They are betting that enforcement will blink first. Most of the time, that bet pays off. Courts issue orders, agencies stall, months pass. Public attention moves on. That pattern teaches institutions a dangerous lesson. Consequences are negotiable. But contempt power exists precisely to break that cycle. It is the judiciary's last line of defense when compliance becomes optional, not symbolic authority, coercive authority. That is why Judge Berman's insistence mattered. He wasn't reacting to a single refusal. He was responding to a pattern that had already crossed from legal resistance into institutional defiance. And here is the crucial point. Once courts allow delay to substitute for compliance, law enforcement officials effectively gain veto power over judicial authority. That is not separation of powers. That is inversion of it. By the time this confrontation reached its peak, the court wasn't asserting dominance, it was reclaiming relevance. And that reclamation always carries risk. The second crisis wasn't triggered by defiance. It was triggered by certainty. When the judge laid out the consequences step by step, this stopped being a standoff and became a countdown, a deadline, a warrant, federal marshals, custody. No appeals before arrest. No political mediation, no institutional shield. That specificity mattered because systems don't panic when rules are abstract. They panic when enforcement becomes concrete. In that courtroom, power shifted visibly. The confidence that had sustained months of obstruction evaporated. Legal arguments collapsed under the weight of enforcement authority that could no longer be ignored. This is the moment many institutions fear most. When delay fails. When ambiguity disappears. When consequences arrive on a calendar, not as rhetoric. And here's the uncomfortable truth. Once a federal judge publicly commits to arrest, backing down becomes harder than following through. Judicial credibility is on the line. That is why this moment escalated so fast. The court had crossed from warning into action. At that point, compliance was no longer a legal question. It was a survival calculation. And when survival enters the equation, systems reveal who they were really protecting all along. Now I want you to step out of the courtroom and think about what this means for you. Because when the head of the FBI can ignore court orders for months, the message doesn't stop at Washington, it travels downward. It tells every agency, every official, every system that rules are flexible depending on who you are. And that always lands on ordinary people first. It means accountability becomes uneven. Justice slows down for some and disappears for others. And trust, the invisible glue that holds democracies together, starts to dissolve. You may never file a subpoena. You may never face a federal judge. But you live inside the system their choices shape. When enforcement is selective at the top, it becomes arbitrary at the bottom. That's why this moment matters beyond politics. It defines whether institutions still protect citizens or merely shield power. If you've ever wondered why faith in democracy feels thinner, why rules feel inconsistent, why consequences seem uneven, this is part of the answer. If this perspective resonates, share it. Not to take sides, but to remind others that systems only survive when law applies equally. Because once equality before the law erodes, it rarely comes back quietly. What happens inside American courtrooms never stays there. Around the world, institutions watch moments like this closely, not for moral lessons, but for signals. Signals about whether the rule of law in the United States is enforceable or merely performative. When a federal judge has to threaten the arrest of the nation's top law enforcement official, allies notice. So do adversaries. Because credibility is not built on speeches, it's built on enforcement. If executive officials in the world's most powerful democracy can defy courts without consequence, it weakens every legal norm the United States claims to defend abroad. It gives cover to authoritarian systems that argue courts are decorative, not binding. And it sends a dangerous message to fragile democracies watching from the sidelines: power outruns law. This is why the December deadline mattered globally. It wasn't just about compliance. It was about whether American institutions still resolve conflict through law or through raw political leverage. Judicial authority, once visibly tested, must either hold or fracture. And when fracture becomes visible at the center, the shockwaves travel far beyond borders. What comes next will not just define this case, it will redefine how seriously the world takes the idea that no one is above the law. From this point forward, the system faces three possible paths. The first is compliance. Documents are released. Court orders are obeyed. The immediate crisis deflates. This would reaffirm a basic democratic truth: no office outranks the law. Institutions survive not because they avoid conflict, but because they resolve it through enforcement. The second path is partial compliance. Selective disclosure. Delays wrapped in cooperation. This is the most tempting option and the most dangerous. It preserves appearances while hollowing out authority. Law looks intact, but enforcement becomes conditional. That is how trust erodes quietly. The third path is defiance. Arrest. Detention. An institutional shock unlike anything modern America has seen. Short-term chaos, long-term precedent. Because once a court jails the nation's chief law enforcement officer, the message becomes unavoidable. Position does not shield you from consequence. Each scenario carries cost, but only one preserves legitimacy. History shows that systems rarely collapse because they choose accountability. They collapse when they postpone it until enforcement becomes traumatic. This moment forces a decision not just from one official, but from the structure itself, whether law remains a ceiling power cannot break or a floor power stands above. What happens next will tell us which one this system still believes in. And that brings us to the final question: what this moment ultimately teaches us. Moments like this are uncomfortable because they strip away comforting myths. The myth that institutions always self-correct. The myth that power naturally respects boundaries. The myth that democracy fails only through dramatic collapse. In reality, systems fail when enforcement hesitates and survive when it doesn't. What Judge Berman did was not radical. It was fundamental. He reminded the system of something it had begun to forget. Courts are not advisory bodies. They are enforcement mechanisms. Without that, law becomes suggestion, and power becomes arbitrary. This confrontation was never about one man or one set of documents. It was about whether the rule of law still has teeth when tested at the highest level. You are living inside that answer. Because the precedent set here will shape how accountability works or doesn't for years to come. It will determine whether future officials fear consequences or simply calculate delays. If this analysis gave you clarity, not outrage, share it. That's how understanding spreads faster than distortion. And stay with me, because this case doesn't end with a deadline. It opens a new chapter in how power, law, and accountability collide. And the next test will come sooner than most people expect.